Deputy Medina with the Flag County Sheriff's Office, okay? The reason for the stop today is not only did I watch you drive the wrong direction on Palm Coast Parkway, you went eastbound in a westbound lane, okay? It's a one-way lane. You went eastbound in that lane, okay? You pulled out of the apartment complex, which I watched you turn around in. You pulled back out. You came back out. You failed to yield to oncoming traffic, 1. 2, you also did not stop prior to entering a public roadway from a private roadway. Does that make sense?
On a Florida roadway, a routine traffic stop triggered by wrong-way driving escalated into a DUI investigation, a drug seizure, and a felony arrest. Every legal question that matters in this encounter traces back to one document: the Fourth Amendment. The stop itself is constitutionally unimpeachable. Under Delaware v. Prowse, decided by the Supreme Court in 1979, a traffic stop is lawful whenever an officer possesses reasonable, articulable suspicion that a traffic violation has occurred. Wrong-way travel on a divided roadway, failure to yield to oncoming traffic, failure to stop before entering a public road from private property, running a red light, and coming to rest in an active intersection. Each of those is an independent violation of Florida Statutes Chapter 316. Any one of them suffices. Together, they are overwhelming.
Is there any... Can you roll this down, please? I know it's just your child. Just roll that down for me. Okay.
I'm not from here.
Okay, where there's big red signs that say do not enter. Or wrong way. Or there's one-way signs there all over, okay? With that being said, you've committed multiple traffic infractions. When I initiated my traffic stop, you stopped in the very middle of the intersection. Do you understand that? Do you understand how dangerous that was for not only your passenger, but the child in the back seat of the vehicle for stopping in the direct intersection prior to me even initiating my traffic stop? Does that make sense? Before I even initiated my traffic stop, before I turned my lights and my sirens on, you were in the middle of the intersection. You had stopped in the middle of the intersection. You ran the red light and continued to sit in the middle of the intersection. Okay. With that being said, step out of the vehicle for me.
Can I take my seatbelt off?
Yep, you can take your seatbelt off.
So why am I stepping out of the vehicle?
You're stepping out of the vehicle for our safety, for your safety, because I believe at this point you might be intoxicated. You have not listened to any of my instructions. You ran past the red light. You didn't stop. You continued forward, and you cannot answer simple instructions. So I need you to step out of the vehicle. Okay, step back here for me. Is your driver's license in the car?
Yes.
Okay, is there registration or anything to the vehicle? Yep, that's fine.
Yeah, it's registration.
Can you just stay up here with her? All right, let's hop back here. Is the vehicle...
My driver's license is in my purse.
Can she get it for me?
Yeah, she can get it.
Ma'am, can you do me a favor? Can you give me her driver's license? She said it was in her purse. Yeah. Oh, baby.
I know, sorry. I asked her to do me the favor to take me to his dad because it's his time to get on my car, so. And that's his dad's car right now.
What's that, ma'am?
She was doing me the favor of taking me to his dad, and so he's like, he was crying, so I wasn't paying attention to what she was doing.
Car smells of 31. Back here. You can lean your butt up against my car because you look like you're having a hard time keeping your balance. Okay. It's okay. I get it's cold, all right? The only reason I'm so frustrated with you right now is not only did you put multiple citizens in danger, you put your passenger and that child in danger, okay? I hadn't even lit you up with my lights, and you'd run the red light, and you were sitting in the middle of the intersection.
You're talking about this light
This
right
one
here?
right here. You ran the red light, and you were sitting in the middle of the intersection.
You had your lights on.
That was before I even had my lights on. You can watch the Axon video of it from my dash cam. Okay? Is there a reason why you might be having such a hard time following traffic laws tonight?
Yes, I'm coming from Orlando.
Okay.
And we're trying to figure out what we're doing because, okay, we're supposed to be dropping her son off.
Okay.
And I thought that we were going to Savannah.
Okay.
To meet up with her baby father's mom.
Okay.
I thought that she was gonna meet us there.
In Savannah.
Yes, in Savannah. They're coming. The father lives in South Carolina, somewhere in South Carolina.
Okay.
And so, like, it was just a big misunderstanding, and so it was like a mix of plans.
Okay.
And
So do you live in Orlando?
yes, I live in
Okay.
Orlando.
So you live in Orlando. What's with the West Virginia temp tag?
This is my family friend's car.
Okay.
Yes.
How do you know her?
I knew her for like a few months. She's just from like a mutual friend. She did me a favor because she lives close by.
Okay.
'Cause
Whose
I was
car is
using-
this?
Oh, this is her car. I can't drive my car. That's why
Okay.
I asked her because I was supposed to be driving to. His dad was supposed to meet me in Savannah. So I told her just to go to DeLand. She has a house there, and to just rest because I could tell she was like a little tired. So she got pizza and stuff. But I just linked up with her. So
Okay.
I would have, if I noticed she was doing something off, I would have realized it, but I was paying attention to it, so I don't know
What do you mean?
Because he was crying, so I was like,
You said something off. What do you mean by something off?
like because she said that she like, went in like a do not enter or something.
Yeah, she was driving the wrong way down the road.
I did not. Yeah, I didn't see that at all.
Okay. You don't live here?
No.
No. Where are you trying to get to?
I'm trying to get to his dad.
Which is where?
In Savannah. So I asked
Georgia.
her, yeah, but because it's already getting late, I was like, let's just go to DeLand because she has a house there, and let's just sleep there and then continue in the morning. So that's why she was trying to like do a U-turn and stuff. Because we were just gonna continue to Georgia.
Check. She's saying she hasn't had anything to drink. I'm not smelling anything. The car reeks of weed, and she's slurring. Her eyes are bloodshot. She's driving the wrong way on the road. She's not listening to instructions. Like,
Okay.
can you do your evaluation and see if there's anything there?
I can't do my evaluation on the side of the road.
All right.
I can't do that. You have
Um,
she has to be 10:15 at the jail. I can't do
All
my
right.
evaluation.
I'm gonna toss this car.
Okay.
Would you help me with that? I think Tori's a bit.
Before you get to
She's-
that, you want a signal 1 investigation?
It's hard to tell. I can't tell if she's cold or if she's under the influence of something.
You do your investigations. You run this through fields. You do your investigation, and then you make a decision based on totality.
I know that she was pregnant. I was explaining to him that I asked her to take me to Savannah.
They're trying to get us Savannah.
Yeah, from
To
Orlando.
Savannah. From Tampa.
From Tampa. So how long have you guys been driving tonight?
Not for long.
Not for long. So is there a reason why she might be so tired? Because
She's exhausted. She's exhausted. I linked up with her recently. I told her, hey, go back to the lane. She has a customer. And I was like, let's just
I'm sorry. Can you say that one more time?
Yeah, I told her she was going to keep going to Savannah. But I said, hey, let's go to the lane because she has a house there. So I think that's why she was like trying to turn around and stuff.
So turned around?
I was paying attention to the baby.
All right. Do you have a medical marijuana card?
I don't. I think her
Okay.
boyfriend does.
Okay. I'm not saying anything. Alrighty. How long have you been driving tonight?
From Orlando,
Or do you mind
probably about 2
standing
hours.
with her? No, right here for a second.
Because we're 50 minutes away from DeLand, and DeLand is about an hour away from Orlando, so probably about close to 2 hours.
Give me a second. 1 second.
Whose car is this?
It's a family friend.
Okay, it's a family friend. Okay.
Yes, sir.
All right. So here's the deal, okay? Deputy Medina's already explained it to you. We're doing a DUI investigation, okay? All right.
The order to exit the vehicle also requires no analysis. Pennsylvania versus Mims, 1977, held that a law enforcement officer conducting a lawful traffic stop may order the driver out of the vehicle as a matter of course, no additional justification required. That authority is categorical and has never been narrowed. The DUI investigation predicate rests on the totality of impairment indicators. Florida Statute Section 316.193 does not require a measurable blood alcohol concentration. It requires only that the driver's normal faculties be impaired. Normal faculties are defined by Florida courts as those used in everyday life: seeing, hearing, walking, talking, judging distances, and operating a vehicle safely. The indicators observed here an odor of marijuana emanating from the vehicle, bloodshot eyes, slurred speech, unsteady gait, and failure to follow simple instructions satisfy the NHTSA impairment threshold individually and collectively. Officers are trained under the Drug Recognition Expert Protocol to identify cannabinoid impairment distinct from alcohol. Odor alone, under State v. Betts, decided by the Florida Supreme Court in 2002, establishes probable cause to search.
Now's your time to be honest. Have you consumed any alcohol? Okay, have you consumed any narcotics? Marijuana, ecstasy, heroin, cocaine, prune juice, I don't know, anything at all. Do you take prescription medication? No? Okay. All right. So, I'm going to check your eyes, okay? Do you have any head trauma? Have you ever been told you have a TBI? You would know because that would be explained to you. It's a huge thing. So, you've never been told you had TBI? Okay. All right. Have you ever been told by an eye doctor or an optometrist that you have what's called resting nystagmus? No? All right. Do me a favor. Stand with your feet together like this. Perfect. No, together like this. All right. Take your hands out of your pocket. Put them down by your side. All right. You see my pretty blue light? All right. I'm going to move this around. Follow it with your eyes and your eyes only. Don't move your head, okay? Do you understand it so far? Yes. All right. I'm trying to write in my face. No rest in my sadness. People's head. Don't move your head.
3 standardized field sobriety evaluations were administered. The National Highway Traffic Safety Administration has validated exactly 3 the horizontal gaze nystagmus, the walk and turn, and the one-leg stand. These are the only evaluations accepted by Florida courts as reliable indicators of impairment. Non-standardized tests carry no evidentiary weight. The horizontal gaze nystagmus test evaluates involuntary jerking of the eyes as they track a moving stimulus, a reflex exacerbated by central nervous system depressants, including alcohol and THC. 6 possible clues are assessed: lack of smooth pursuit, distinct nystagmus at maximum deviation, and onset of nystagmus prior to 45 degrees in each eye. 4 or more clues correlate with impairment above 0.08 BAC in NHTSA validation studies.
What we're going to do is we're going to walk across there so it's a flat surface for you to walk on, okay? We'll go from there. I know it's cold and windy. Let's try and get this over with. All right, let's walk over. Okay. All right, with that being said, you're going to place your left foot on the line, okay? You're going to place your right foot on the line ahead of your left foot with the heel of your right foot against the toe of your left foot. Okay. Place your arms down at your sides. Maintain this position until I have completed the instructions. Do not start to walk until I've told you to do so. Do you understand these instructions so far? Do you have any questions about these instructions so far? Okay. When I tell you to start, take 9 heel-to-toe steps on the line. Turn and take 9 heel-to-toe steps down the line.
All right. Whenever you're ready to begin, you may begin.
I count?
Yes.
Yes, ma'am. You count out loud each step.
1, 2, 3, 4, 5. Oh, I'm sorry. 5, 6.
On the walk and turn. NHTSA protocol identifies 8 clues losing balance during instructions: starting too soon, stopping mid-walk, missing heel-to-toe contact, stepping off the line, using arms for balance, making an improper turn, or taking the wrong number of steps. 2 or more clues is the threshold for a positive result. The subject lost count between steps 3 and 5 on the return pass. That is a scored clue, regardless of the environmental conditions present. Defense counsel will argue that cold temperature, wind, and bare feet on pavement compromise the walk and turn's reliability. That argument has limited case law support in Florida. Courts have held that officers must note those conditions in their report, and that the conditions go to weight, not admissibility. The test results come in. The jury decides what to make of them. The one-leg stand was completed without obvious instability. NHTSA's 4 clues: swaying, arms used for balance, hopping, foot touching down, were not clearly observed here. That is a notable data point. 2 out of 3 standardized tests showing impairment clues, combined with the driving pattern and officer observations, creates a sufficient probable cause basis for a DUI arrest under Florida law.
9. And 9 turn around. Can I try this with my shoes on?
What's that?
Can I try with my shoes on?
I asked you if you're comfortable in yourself.
Yeah.
Don't stop the exercise. I can't help you, friend. That's why I asked you if you had any questions. You gotta continue on.
So 9 turn around. Because this is my next foot.
Okay.
Alrighty, turn around for us. Hands out of your pockets for us. I know it's cold, I'm sorry, but just feet together, hands each side. Like so, like Deputy Harmon's doing, okay? Do not start until I tell you to do so. Do you understand the instructions so far? Okay. When I tell you to start, raise either leg with the foot approximately 6 inches off the ground, keeping your foot parallel to the ground, okay? You can use either leg, right or left.
Which foot are you gonna raise?
Right?
Right foot.
Right foot.
Alright. Alright, you may begin.
1001, 1002, 1003, 1004, 1005, 1006, 1007, 1008, 2009, 2010, 2011, 2012, 2013, 2014, 2015.
Alright, you can stop. Alrighty, we're gonna walk back over the patrol cars once it's safe, okay?
Alright, ma'am. You're being placed under arrest for driving under the influence, okay? Alright.
What?
Mm-hmm. Based on everything that we observed, your driving pattern, you're under the influence of something. Okay? You're driving the wrong way down the street with a baby in the car.
Alright, put your butt in first.
Now the encounter becomes constitutionally complicated. Once the subject was handcuffed and secured inside a locked patrol vehicle, she was in custody under any reasonable application of Miranda versus Arizona. The Supreme Court established in 1966 that custody plus interrogation requires prior advisement of rights. Both elements were present. The Miranda warnings were not delivered until well after questioning about vehicle contents had already produced incriminating responses. The legal test for custody is objective. Would a reasonable person in the same circumstances feel free to leave? A person handcuffed in the rear of a locked patrol vehicle would not. Florida courts have consistently found custodial interrogation in materially identical factual contexts. The remedy is suppression under the exclusionary rule established in Mapp versus Ohio. The United States Supreme Court addressed this exact sequencing problem in Missouri versus Seibert in 2004. Seibert prohibited the deliberate two-step tactic of questioning before Miranda, obtaining admissions, then re-eliciting the same statements post-advisement. Whether the sequencing here was deliberate is a factual question for the court. But even without deliberateness, the Seibert analysis applies when the pre-warning statement was effectively confirmed post-warning.
I can't stand here all night. Just tell me the truth. The truth is easier to remember than a lie. It's easier to be honest with you. Tell me what's in that car. I'm not gonna find it. Just tell me what's in that car. If you're honest with me, I put that on a report. If you're honest with me, it goes a long way. And if I shut this door, I'm telling you, I know something's in this car. I know something's in this car. Just because you're hesitating to tell me something. So just be honest with me, because it's going to go a long way. If I don't have to tear this car apart, and you just tell me where it's at, then there's no issue. What's that?
I don't know if I know she's supposed to be, but I don't know if she already leaves or.
Okay, is that the only thing that's supposed to be in the car? Cigarettes?
Yeah, cigarettes. I don't know if I think she had bugs though.
A bunch
She
of them?
wasn't, yeah, but she wasn't driving, so.
Okay, that's fine. What does a buzz ball look like? I've never seen that one.
It's like a,
Is it like a roach? Or is it like a bomb?
oh no, buzzball's like a, like from college, like a little, like, it looks like a ball inside a alcohol drink, from gas stations.
Oh, one of those little. Oh, okay. Alright. Give me a second, I'll be right back, okay? Is that it? Like I said, this is your opportunity to be honest with me.
Yes.
Okay.
To my knowledge, that's it.
What's that?
To my knowledge, that's it.
Okay. So she is saying, well, we found the buzz ball. Okay. She is saying that marijuana is her boyfriend's.
Huh?
She's saying that the marijuana is your boyfriend's because he has a weed cooker.
The marijuana is her boyfriend. His name is Jerry. And
The one in Savannah.
Savannah?
She's saying that the baby daddy's in Savannah. Is that the
Georgia?
boyfriend?
That's
or-
her baby daddy.
That's not boyfriend?
No.
Oh, okay, okay.
She
I'm
got
not
that
confused.
weed from her boyfriend.
Okay.
Because her boyfriend has a dispensary card.
Okay. Alright. Now, where is that at? Because I can smell it. So,
I don't know where it's at.
is it in her stuff?
Yes, if she didn't smoke it all, then it's in her stuff. Because I don't smoke.
I got you. Like I said, the honesty goes a long way. So if I find it, since you told me about it, I don't care. Weed is weed. But if we find out she's lying to me, I'm going to have an issue with that. Because right now she's saying that it's your boyfriend's.
like Walgreens app where I have
I
that
see
many
it.
prescriptions.
That's why I asked you. It's a little bit faded. That's why I asked you. I can see the Z.
Yeah.
But I can't see the, now I'm trying to see the hydroxy Z. That's fine. If it's your prescription, that's fine. Alright. I'm going to ask you only one time only before I shut this door and I go test this. What is this? What is this? It's empty, but there's still residue in it, so I can still test it. What is it? It's in your stuff. What is it? Okay, when I shut this door, all bets are off. You can see the white residue in it. What is it? I don't know. You don't know? It's in your bag. Okay, what is it supposed to be? I believe so. People don't carry this little tiny bag like this. What is this? No. You don't understand you're in possession of it, so if it pops out for anything, you're going to go to jail. So you want to tell me what it is? Okay.
The drug possession charge implicates a second constitutional doctrine. THC vaping pens and a joint were discovered inside the subject's bag, her personal bag, inside the vehicle she was operating. Florida Statute Section 893.13 prohibits actual or constructive possession of a controlled substance. Cannabis and cannabis extract remain Schedule I controlled substances under Florida law. Constructive possession requires the prosecution to prove three elements. First, that the defendant knew of the presence of the contraband. Second, that the defendant knew the substance was illegal. And third, that the defendant had the ability to exercise dominion and control over it. Contraband found inside a person's own bag creates a near irrebuttable inference of both knowledge and control. The defense will argue that the items were placed in the bag by the vehicle's registered owner without the subject's knowledge, a theory the subject herself raised inconsistently during questioning. Florida courts have held that inconsistent and shifting accounts of how contraband came to be in a defendant's possession are themselves evidence of consciousness of guilt. Admissible at trial. The quantity and form of the THC products determines the charge level. Cannabis flower, a joint, is a first-degree misdemeanor for amounts under 20 grams and a third-degree felony for amounts over 20 grams, under Section 893.136. THC vaping pens contain cannabis extract, which Florida courts have treated as a concentrated form of cannabis. Prosecutors have successfully argued that concentrated THC products warrant felony treatment independent of weight. The subject faces potential third-degree felony exposure. One additional item recovered, a small container with white residue, was presented to the subject with a direct question. Her response that she did not know what it was, despite it being found in her bag, will be difficult to sustain. Prosecutors need only show she was in possession of a container with residue of a controlled substance. If the substance tests positive for cocaine, fentanyl, or methamphetamine, the charge level rises significantly and the case changes entirely.
has the card. She uses the card. Perfect. I appreciate you. Thank you.
She keeps lying to me, and she says she hasn't used any of the products. She keeps lying to me about it. About the THC. So she's going. Cool. Just put your hands on her back. Alright, you're being placed under arrest, okay? You're being placed under arrest for the THC pens. You keep lying to me about it. Alright? Whether or not she put it in your bag, she's claiming that you have gotten it from your boyfriend, which is accurate to the story you told me, that you got it from your boyfriend and that he put in there. You ended up telling me that she might have put it in there, but then you continuously kept telling me that your boyfriend put it in there for you. Yes, I would love for you to explain.
In our predicament, okay? Our perspective, I want to believe you. I wish I could believe you, but what you're telling me may make sense to you, but it doesn't to me. Okay? Because if you are being warned that you may have something that you're not supposed to have in your possession after you leave, mind you were warned.
I'm saying like
In general, as well as what is in that lunchbox? Like what that lunchbox? Why is it so important?
I didn't know.
But he's not here, so why'd you take it?
Because I just took it because I use it too. Like I literally was like rushing out. I live with my mom, so everything's out in the open, right? So if I knew that was enough, his whole family knows he has his card.
Okay, but do you have a card? That's the question. I think that's what Deputy Mink is explaining.
But it's not mine, though.
Okay, so what I've gathered so far. Okay, hear me out. And you're saying that I'm not frustrated with you. Okay, what we're trying to do is we're trying to get down to the bottom of what's going on. You're good. What's going on is
Stand by with this.
yeah, you're fine.
It seems like I'm lying. I'm so frustrated. I'm pissed off. I don't know why.
I would see why you're pissed off because your friend is driving inebriated with your 2-year-old in the car.
I would never. If she was swerving, I would not. I would not.
She wasn't just swerving. You guys were driving into oncoming traffic.
I didn't see that because I was like placing my baby,
The-
and then I saw
Regardless
your
of
legs.
that, the issue that we're coming across here is that you're lying to us. Okay, this could be easily settled. All right. You have the THC pins in your possession, in your bag. You've told me already that they are your boyfriend's, right? We've already. Hear me. Let me walk you through it. Let me walk you through it. Okay, you've told me already that the THC pens are your boyfriend's.
I'm just pissed.
Hear me out.
I don't know. She was.
I get it. You're pissed right now because you're right here in handcuffs. You got your 2-year-old. The whole situation is very
I'm
shitty. I get
pissed
it.
when I saw this light. Something like could happen, and I would never, ever, ever when I didn't do it. I've never gotten in trouble. I drive like I literally like I don't. My whole life has gotten, and I would never, ever put him at risk. I'm so sorry. It seems like I'm lying. I'm literally just like it says it's not mine, but I don't have my name. The lunchbox. Okay, so for example, like,
Hold on. You good for a second? Okay. Hey, so what we're gonna do? Turn around for me. I'm gonna take these off. Okay, I'm gonna explain to you.
Before you unhandcuff her. All right, turn around and lean up against the car. What is your first name? First name.
Liz, okay? I don't know what you told us, Devin, okay? I don't know. I wasn't there when you spoke to me, okay? Here's the deal, okay? You could be going to jail tonight over some stupid THC. It's a felony, all right? But what we're not gonna do is separate you from that baby. So what Deputy Medina is gonna do is she's gonna forward charges to the state attorney's office for what we would have taken you to jail for. So basically, the charges go to the state attorney's office. If they decide to file on you, then you'll be contacted. Make sure you give her the appropriate contact information, mailing address, phone number, and all that. Okay? If you don't go to court and take care of your business, you're going to have a warrant. It's a felony warrant.
okay, I will handle that immediately.
Okay. But you need to understand that you need to pick better friends. This person is driving the wrong way down the street with that baby in the car. I'll be honest with you. I don't care about it. And I don't care about what you're doing. I care about that innocent baby right there that is beautiful.
The officer's decision to forward charges to the state attorney's office, rather than physically booking the subject, is legally permissible under Florida Rule of Criminal Procedure 3.125, the Notice to Appear framework. Officers have discretion to issue a notice in lieu of physical custody when the individual is not a flight risk and no public safety need requires detention. The subject's 2-year-old child was the stated reason for this discretion. If the state attorney files charges and the subject fails to appear, a capias, a felony arrest warrant, issues as a matter of course. At that point, The discretion exercised tonight becomes irrelevant. The subject was correctly advised that appearing and engaging counsel is not optional. Ignoring a notice to appear converts a manageable criminal exposure into an active warrant. Deputy Medina receives a B-. The stop was textbook. The impairment observations were articulate and legally precise, and the decision not to separate the subject from her child reflects a mature exercise of law enforcement discretion. The deduction is for the pre-Miranda custodial interrogation. Once that patrol car door closed and the subject was restrained, every question asked without a Miranda advisement was constitutionally deficient. That error may not cost a conviction, but it hands the defense its best motion. The second deputy receives a B+. His field sobriety administration was methodical and substantially protocol compliant. His explanation of the legal process to the subject was accurate, fair, and more thorough than most encounters of this type produce. The same pre-Miranda sequencing issue applies equally to his conduct. His strength is in the investigation. His vulnerability is in the interrogation room. The driver receives a C+. She endangered her passenger, her child, and other motorists through conduct that the officers documented thoroughly. More damaging legally, her statements were inconsistent on the central factual question of the evening. She told 3 different accounts of how THC products came to be in her bag. Inconsistency of that kind has one function at trial: it destroys credibility. Her best legal argument is suppression of the pre-Miranda statements. If that motion fails, the remaining evidence is formidable. The passenger receives an A-. She cooperated completely. Her account was consistent throughout, and she did not obstruct the investigation in any way. The deduction is not for her conduct with law enforcement. It is for the threshold decision to enter a vehicle operated by an impaired driver with a 2-year-old child aboard. No amount of cooperation after the fact changes what that decision exposed the child to. 4 legal lessons emerge from this encounter. First, the timing of Miranda is not a technicality. It is a constitutional boundary. Once a person is in custody, questioning before advisement creates suppressible statements. Officers who delay Miranda to elicit pre-warning admissions are not gaining evidence. They are creating reversible error. Second, constructive possession is not a defense because the contraband is not literally on your person. Courts will ask what you knew, what was accessible to you, and what was in your bag. If the answer to all 3 is unfavorable, possession is established. Claiming the items belong to someone else requires consistent, credible evidence, not a shifting account produced under pressure. Third, field sobriety tests are not pass-fail exams with a known score. They are structured observations that produce clues. Each clue is documented, reported, and testified to. Environmental conditions, cold, wind, bare feet, go to weight, not admissibility. A driver who performs imperfectly on 2 of 3 evaluations after driving the wrong way down a public road has a difficult defense. Fourth, a notice to appear is not a dismissal, and it is not a favor. It is a deferred consequence. The state attorney still receives the file. The charges are still evaluated for prosecution. A court date still issues. Failure to appear converts that deferred consequence into an active felony warrant. The officer's discretion buys time, nothing more. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to the channel for even more police interaction and courtroom content.